1200 words at the speed of 120 words per minute. Be ready. Start. The appellant married the daughter of respondent number 1 as per the Islamic rites and customs. Stop. Two children were born out of the wedlock. Stop. Appellant's wife died after 13 years of marriage and within a year he married again. Stop. Respondent number 1 maternal grandfather. Respondent numbers 2, 3 and 4 maternal aunt and uncles of the minor children, girl aged 13 years and boy aged 5 years, initiated proceedings under sections 7, 9 and 17 of the Guardian and Wards Act 1890 for appointment as guardians. Stop. They also filed application under section 12 of the Act praying for interim protection of the persons and properties of the minor children and also for an injunction restraining the appellant from interfering or disturbing the custody of the minor children. Stop. Family Court passed an interim order restraining the appellant from interfering with the custody of the children with the respondent. Stop. Appellant challenged the order. Stop. Family Court set aside the said order of injunction. Stop. High Court set aside the said order and passed certain directions. Stop. Hence, the present appeal was made by the appellant in this court. Stop stanza. Sections 12 of the Guardian and Wards Act 1890 empowers court to make such order for the temporary custody and protection of the person or property of the minor as it thinks proper. Stop. In matters of custody, welfare of the children is the sole and single yardstick by which the court shall assess the comparative welfare of the children is the sole and single yardstick by which the court shall assess the comparative merit of the parties contesting for custody. Stop. Therefore, while deciding the question of interim custody, the court must be guided by the welfare of the children since empowers the court to make any order as it deems proper. Stop stanza. With regard to guardianship, the prima facie case lies in favor of the father as under section 19 of the Act. Unless the father is not fit to be a guardian, the court has no jurisdiction to appoint another guardian. Stop. Respondents, despite the voluminous allegations levelled against the appellant, have not been able to prove that he is not fit to take care of the minor children, nor has the family court or the high court found him so. Stop. However, the question of custody is different from the question of guardianship. Stop. The father can continue to be the natural guardian of the children. Stop stanza. However, the considerations pertaining to the welfare of the child may indicate lawful custody with another friend or relative as serving his her interest better. Stop. The question of guardianship can be independent of and distinct from that of custody in facts and circumstances of each case. Stop. The court shall determine whether in proceedings relating to interim custody there are sufficient and compelling reasons to persuade the court to change the custody of the minor children with immediate effect. Stop. Stability and consistency in the affairs and routines of children is also an important consideration. Stop stanza. Keeping in mind the paramount consideration of welfare of the children, the custody of the children which currently rests with their maternal relatives is not disturbed as the scope of this order is limited. Stop. The appellant, in response to these submissions, contended that the High Court could not interfere with the findings of the family court unless serious infirmity is proven. Stop. The decisions cited by the respondents were distinguished on the ground that these decisions concerned findings that were recorded after a full-fledged trial and not an order passed as an ad interim relief granting custody to one of the parties. Stop stanza. The High Court, in its impugned judgment, had held that while appointing the guardian or deciding the matter of custody of the minor children during the pendency of guardianship proceedings, the first and foremost consideration for the court is the welfare of the children. Stop. The factors that must be kept in mind while determining the question of guardianship will apply with equal force to the question of interim custody. Stop. It was observed that this family court should have delved a little deeper into the matter and ascertained where the interest of the children lay instead of recording abstract findings, questions of prima facie case, balance of convenience, and irreparable injury. Stop. The terms on which the appellant and his deceased wife were the manner in which the respondents obtained the custody of the children are questions that should be determined during the course of trial. Stop. Though when the children's father is not unfit, otherwise he shall be the natural guardian. A child cannot be forced to stay with his her father. Stop. According to the High Court, merely because the father has love and affection for his children and is not unfit to take care of the children, the welfare of children cannot be guaranteed. Stop stanza. The present appeal by special leave is directed against the order dated 1st October 2012 passed by the High Court, whereby the learned single judge in exercise of the jurisdiction under Section 439 to read with Section 482 of the Code of Criminal Procedure 1973 has set aside the order dated passed by the learned Additional Sessions Judge Saket Courts, Delhi, who had granted the benefit of anticipatory bail to the appellants in FIR number AA instituted for the offence punishable under Section 420 IPC, registered at Police Station Defence Colony, New Delhi. Stop stanza. The factual matrix that is required to be exposited for the purpose of disposal of the present appeal is that the second respondent filed an FIR against the present appellants, alleging that both of them had conspired against him and in furtherance of the said conspiracy they had subjected him to cheating, criminal breach of trust, and have misappropriated the money. Stop. As alleged in the FIR, the appellants allured the said respondent to buy a property situated at Lodhi Road, New Delhi, for which he paid an advance of rupees 1 crore. Stop. As the narration would unfurl, it was apprised by the appellants that the property comprising entire basement floor and entire ground floor with one servant and impartible share of ownership rights in the land underneath would be sold to him and he will be delivered vacant, peaceful physical possession. Stop. There are series of other allegations which would show that on the basis of oral agreement certain amount was paid and on 30th April 2013 an agreement to sell was duly executed between the parties. Stop. It is also the case of the informant that remaining part of the amount, that is rupees 4 crores, was to be paid to the accused persons at the time of registration of the sale deed on or before 26th September 2011. Stop stanza. As the allegations proceed after receipt of the amount, The appellants disputed the amount and delayed the execution of the sale deed stop. On an enquiry being made, the second respondent came to know that the appellants had entered into an agreement to sell the said property to a third person stop. That was the foundation to lodge the FIR stop. After the lodgement of the FIR, the appellants moved an application under Section 438 CRPC for grant of anticipatory bail stop.